Let's go back to the Midwest. Senator Franken.
Thank you, Mr. Chairman, and thank you for calling this hearing. Thank you to all the witnesses. I'm sorry I had to make a vote on another committee, so I missed Mr. Fox and Mr. Foreman. First, I just want to say something to Ms. Jones. Yesterday, we had an amendment to the Department of Defense appropriations, and we passed a bill quite handily saying that we're not going to hire contractors who do mandatory binding arbitration on things like sexual assault. Mm-hmm. And we had a little press thing afterwards, and I talked about your courage and your persistence. One thing I left out is your strength, and I want to thank you for that.
Thanks.
You're an amazing young woman. Mr. Bernardo said that you've had your day in court.
He did say that.
Isn't it true that what you've been in court doing is trying to get your day in court?
Exactly. I wanted to quote him, actually. Justice delayed is justice denied.
He did say that in his
I totally
testimony.
agree with that. I have been fighting arbitration for 4 years. I have been wanting my day in front of a trial by jury for 4 years. I don't believe that claims like this should ever be in front of an arbitrator. They need to be public knowledge. They don't need to be private, discreet, and binding. So I feel that what Bernardo said was accurate about justice delayed is justice denied, but those of us that need this as public knowledge need to not go in front of a secret arbitrator. I was also curious if Bernardo represents individuals or corporations, and also if the polled employees represented likely include people who have gone through the process or have not gone through the process.
Well,
and so that I was kind of curious about that.
I'll ask the questions here, Mr. Chairman. And I do have a question for Mr. Bernardo. You put in your written, oh, I'm sorry, Mr. DiBernardo, excuse me. You said in your written testimony, you write in your written testimony, you cite something which, by the way, in the footnotes, you cite essentially page 30 of a 10-page report, that employees have a 63% chance of prevailing in arbitration and a 43% chance of prevailing in employment litigation, forgetting the fact that the committee couldn't actually look that up. Would you consider if Jamie Lee had gotten a settlement of $50 that she would have prevailed under this definition? Please answer yes or no, sir.
No. I mean, that is, let me just say.
Please answer yes or no, sir. You say no?
I say no.
So in other words, the statistics on who prevailed and who didn't prevail, what would she have needed to have gotten? $100? Would she have prevailed if she had gotten $100?
You know, I think there's a distinction without a difference. What we're talking about.
I answer yes or no, please, sir.
So the question is, what is the number that counts as prevailing?
I think that is sort of the question, isn't it?
You know, what I'm looking at is the research that's been done, the studies that have been done on who prevails in.
Yeah, and I'm saying what's prevailing.
I don't know what their definition is going to be.
You don't know what their definition is. So when you said no, you didn't know whether that was true or not, did you?
Well,
did you?
Senator, if we're talking about an assault or sexual assault or assault and battery or false imprisonment, that's not what I'm here to address. What I'm here to address.
That's what this case was about, sir.
That's
and
what Ms.
the
Jones's
company,
case was
sir,
about.
please. The company asserted that it had the right to arbitrate. In fact, she's been in court 4 years because this, and by the way, they are appealing again. So, You write something that you didn't know about. That's 63% of the time their employees prevail. So presumably, if they, as far as you know, if she had gotten $50, that would have counted under your 63%. And would she also prevailed if she got $50 and that the price of that was her silence?
You know, Senator, I would like to respond, not in yes or no, but a little bit more broadly. And the
Go ahead.
answer is, you know, we go to the research that's out there, we go to the statistics that are available. They're reliable statistics. The question comes in prevail. This is an awful set of facts. The situation that Ms. Jones faced.
I just asked you a question. Would that be considered under your statistic that she prevailed? Because that seems to be part of your case, that this is better for employees. That's your case. So I'm asking, what do those statistics mean? And you don't seem to know what they mean.
Well, I do know
Okay,
what
for
they mean,
example,
because the overwhelming majority of times, 99.999% of the time, the facts aren't going to be anything near what we're talking about here. It's not going to.
But here they are, the facts here, and
This is a
she's been in
criminal
court for
situation.
4 years, sir.
There's a criminal situation. There's a civil action that's.
She had no criminal. This took place in Iraq. So at that time, she had no recourse, sir.
All right.
She has not had her day in court, sir. She has litigated to have her day in court, sir, Mr. DiBernardo.
I would like to address that issue. I'd like to address
No.
that issue in terms of.
No, please answer my question, sir.
Okay.
I read some of your testimony to Ms. Jones. You said that the net result of the use of arbitration is better workplaces.
Correct.
Better workplaces.
Correct.
She was housed with 400 men. She told KBR twice that she was being sexually harassed. She was drugged by men that the KBR employment people knew did this kind of thing. She was raped, gang raped. She had to have reconstructive surgery, sir. They had this arbitration. Now, if that created a better workplace, and then she was locked in a shipping container with an armed guard. Now, my question to you is, if that's a better workplace, what was the workplace like before? That's a rhetorical question. I'm not really asking you that question. They had binding arbitration at KBR. And because of that, and they asserted it on cases like this. And Ms. Jones, in your foundation, you've heard from other women who were raped. Is that not true?
Yes, sir, I have.
And women who, under arbitration,
Yes, sir.
were told to keep silent. Is that right?
Exactly.
And because of that silence, you didn't know about anything like this, did you?
Exactly. I didn't know. It was not public knowledge. Unfortunately. I think it was a very big injustice for it not to be public knowledge. It was an injustice for me and all future mothers, wives, daughters, sisters who want to go to Iraq that don't know about all of the crimes that have occurred overseas because it's been in secret arbitration. It's a big injustice.
And when Mr. DiBernardo said that you had your day in court, what was your reaction?
I was livid, sir. 4 years to fight to get in court is not a day in court.
I was livid too. This is a result of your binding, mandatory arbitration, Mr. DiBernardo. Thank you, Mr. Chairman.